per incuriam is what we're discussing right now. So per incuriam, again, this is is a Latin term for true want of care. True want of care. So when we say a judgment is given per incuriam, we're actually saying that a judgment is given through want of care. We could say through carelessness or through ignorance, and because the court has delivered a judgment without being aware or taking not considering a particular statute or case law that is binding on the court. So that's basically what we mean that a judgment is per incuriam. The judge gave a decision in ignorance, but you know, most of the time it's not right to say that the judge is ignorant. The judge is not meant to be ignorant. The judge is supposed to know the law. The law resides in the breast of the judges, so the judge cannot be said to be ignorant. So we say it's true want of care. It was actually not the lawyers didn't do enough research or things like that. So basically, in the case of Young and Bristol Aeroplane Company, in the House of Lords, we'll look at this case again when we come to discuss the hierarchy of courts. But for now, the part we want to take from this case is that the Court of Appeal was said to be able to depart from its own decisions if the decision is given per incuriam. And the judges now try to explain what per incuriam decision is, and they explain that a per incuriam decision consists of a decision in which the court gave its decision without taking note of a statute or a rule that has statutory effect. Which will have affected their decision if they were aware of it. So basically what we're saying, for example, a rule like the rule of courts that could determine how a process should be done, and it was not taken note of, and the court gave the decision without regarding the statute or the rule, that will have affected the decision. In that particular instance, that case is actually per incuriam. And then in Nicholas and Penny, as well as Huddersfield Police Authority and Watson, the court was also able to show that it's not only statutes and rules, but also to neglect a case law or authority that is binding on the court. For example, if there's already a precedent on that matter and the precedent case was not cited before the court, a precedent that is binding on that particular court and it was cited before the court, that particular case will also be held to be per incuriam. And then finally in Morell and Wickling, Lord Evershed explained that the only instances in which a case can be said to be per incuriam is a situation where it's given in ignorance or in forgetfulness. Ignorance or forgetfulness of an inconsistent statutory provision or authority. Now, but it didn't stop there. That is binding on the court. But it says that the effect of this ignorance or forgetfulness is such that a part of the judgment, or the whole judgment, or a step in the reasoning is now demonstrably wrong. That can be demonstrated to be wrong. So by ignoring the inconsistent statutory provision, like a statute that will have changed the decision of the court if you knew about it, or an authority like that, it now renders part of the judgment or the whole judgment or a step in the reasoning of a judge to be can easily be demonstrated to be wrong. It renders it wrong. So that's the understanding of per incuriam. And then we have a case that I saw about an election petition case of the Action Congress of Nigeria, and Simon Ewule, in which the court overruled 3 of its previous decisions that had to do with Ayuba, for example, Ayuba and INEC, an unrepeated decision. 3 cases actually. The Court of Appeal overruled those decisions based on the fact that they were decided without looking at a particular section of the Election Act, which will have guided the court's decision. Now, that basically takes us through the issue of per incuriam. But you must note, for example, the fact that the lower courts do not have the privilege of refusing to follow the decision of the higher courts on the basis of per incuriam. Now, a court can decide, I will not follow my own decision that is per incuriam, but a lower court, based on the principle of precedent, must follow the decision of the higher court. It's the higher court that has the privilege of saying, okay, this decision is per incuriam, we'll overrule it. So that's why, for example, in England, in the case of Castle and Brome, well, Lord Denning was one of the people who always used to come under criticism, because many of the times they will look at the judgment of the higher court and say that it's per incuriam. And so in Castle and Brome, the court told the lower court that they must not give unasked for advice, that's what we call gratuitous advice, to the higher court, that it doesn't lie within their powers to refuse to follow the decision of the higher court on the basis of per incuriam. And in Nigeria, that position has been settled as well in our law, such as we have Samia and Bauchi Native Authority, in which the courts rebuked the lower court by that they refused to follow a decision of the West African Court of Appeal that was binding on them, and the court said it was wrong, that they should not have done that. And then in UBN and Dairo and UBN, the court also rebuked the lower court that it must not be heard of, because it's the thing that could cause judicial rascality or impertinence if the lower court decides not to follow the decision of the higher court. That's Dairo and UBN. And you also have Bolaringwa and Board of Customs and Excise, Bolaringwa and Board of Customs and Excise, Board of Customs and Excise, as well as the recent 2010 decision in Osakwe and Federal College of Education, Asaba. So that's basically the position that the lower courts cannot, no matter what they think. In fact, I think whether it was I think it's Samia or something, the courts, or was it UBN and Dairo, the courts actually said that no matter how learned the lower court considered itself, or how contemptuous it is of the higher courts, that it doesn't lie within their powers to refuse to follow the decision of the higher court, that they are bound by the doctrine of precedent to follow the decisions of the higher court. So basically, that's all you need to know about per incuriam, through want of care. And the care basically here is talking about the fact that it wasn't careful enough to note all the statute, the rules, the case law, the authorities that are binding on the court in that particular instance. And for your practical purpose, you must realize that that's why being a counsel is actually very important. You're supposed to be a minister in the temple of justice, as well as be of service to your client. And in professional ethics in the law school, you'll be told that you should not even hide from the courts a statutory provision or a case law or an authority that is contrary to your case. It's part of your duty to the courts to be able to guide the court so that it will not make a decision through want of care, because you've done sufficient research and you can show the court that this particular decision says this and it's binding on this particular matter. We'll get to the concept of distinguishing, so you will know, for example, that you can still tell the court that this decision is actually against me, but I can distinguish it in order to make it not applicable in this particular case. So the next discussion we are going to have is the discussion on the principle of distinguishing.